Thank you. I'm delighted to be here. My talk this afternoon derives from a book that I am currently finishing titled Sexing the Constitution, which examines the history of sex, religion, law, and the Constitution. Although the book addresses such issues as obscenity, contraception, homosexuality generally, abortion, and so on, I decided in light of recent events to focus specifically this afternoon on the issue of same-sex marriage, an issue that cuts to the very heart of the meaning of equal citizenship. In August of 1982, an Atlanta police officer went to the home of Michael Hardwick to serve an arrest warrant for public drinking. Upon entering the home, the officer observed Hardwick and another man engaged in oral sex. The officer placed both men under arrest for the crime of sodomy. In Bowers versus Hardwick, decided in 1986, the Supreme Court held that the Georgia homosexual sodomy law was not unconstitutional, noting that the Constitution says nothing about a right to commit sodomy, and that prescriptions against homosexuality, quote, have ancient roots. Justice Byron White, who wrote the majority opinion, concluded that to claim that the Constitution protects a right to engage in such conduct is at best facetious. In a concurring opinion, Chief Justice Warren Burger added that condemnation of homosexual conduct is firmly rooted in Judeo-Christian moral and ethical standards, and that to hold that the act of homosexual sodomy was somehow protected by the American Constitution would be to cast aside millennia of moral teaching. Justice Harry Blackmun, joined by Justices Brennan, Marshall, and Stevens, dissented. Although conceding that traditional Judeo-Christian values had prescribed homosexual intimacy for hundreds, if not thousands of years, Blackmun insisted that that fact alone cannot provide adequate justification for the Georgia law. That certain religious groups condemn the behavior at issue, he reasoned, gives the state no license to impose their judgments on the entire citizenry. To the contrary, the legitimacy of secular legislation, he said, depends on whether the state can advance some justification for its law beyond its conformity to religious doctrine. Finding no such justification, Blackmun concluded that the Georgia statute could not be reconciled with the United States Constitution. That, however, was a dissenting opinion. The court's invocation of moral and religious prescriptions against homosexuality played a central role in the justice's reasoning in Bowers, and it's therefore useful to have some understanding of that history. So let's take a look at the ancient roots that Justice White invoked. The pre-Christian world generally thought of sex as a positive part of human nature. It did not see sex as bound up with questions of sin or religion. The ancient Greeks, for example, focused not on sexual sin, but on whether an individual's conduct was actually harmful to others. And this extended even to homosexuality. Indeed, a common feature of Greek sexual life was that adult men often had same-sex sexual relationships with adolescent boys. This might seem strange to us, but Greek poetry, history, and literature celebrated such relationships and identified them with love, honesty, integrity, honor, and courage. Similarly, although Roman sexual life was different from that of the Greeks, the Romans too celebrated sexual pleasure, and neither Roman religion nor Roman law condemned same-sex sex. The emergence of Christianity, however, produced a profound change in the prevailing understandings of sex. By the end of the 5th century, Christianity had come to condemn sexual desire as inherently shameful and as an evil temptation that must be suppressed. This shift occurred over the course of several centuries, but it was Augustine who finally crystallized the early Christian understanding of sex. In a critical leap, Augustine linked sexual desire to the fall of man. Adam's transgression, he argued, had not been one of disobedience, as the ancient Hebrews had believed, but one of sex. Augustine therefore maintained that every sexual desire is born out of evil, that every child born out of evil is born into sin, and that it is through sex that man passes on the original sin from one generation to the next. Augustine therefore concluded that man's only hope for redemption lay in repudiating the sexual impulse, and with it the burden of sin and shame inherited from Adam. Augustine's vision ultimately shaped the future, not only of Christianity, but of Western culture and law more generally. During the next 1,000 years, Christian dogma, backed by the threat of hellfire and damnation, attained not only religious, but social, political, and legal authority. The sin of sodomy came to be seen as uniquely dire, for as the biblical story of Sodom had taught, for this particular sin, God will punish not only the sinners, but also those who fail themselves to prevent the sin. But it was still unclear precisely what acts constituted sodomy. It was Thomas Aquinas who, in the 13th century, first drew a sharp distinction between opposite sex and same-sex unnatural acts. Although oral or anal sex with a person of the opposite sex was deemed a vice against nature, such acts with a person of the same sex, he concluded, constituted the worst form of sodomy. Before long, Thomas's thinking on this point became the dominant authority in Christian doctrine. At roughly the same time, and not coincidentally, same-sex sex came for the first time to be declared not only a sin, but also a crime. That is, the church for the first time conscripted the secular law to extend its prohibition on same-sex sex not only to those who shared the faith, but to everyone, regardless of their personal religious beliefs. Criminal statutes against same-sex sex were thus enacted throughout Europe, and because of the heinous nature of this crime, these laws called for homosexuals to be castrated, dismembered, burned at the stake, drowned, hanged, stoned to death, decapitated, or buried alive. In short, homosexuals for the first time became the object of a systematic campaign of extermination. Although the Reformation brought about significant changes in the Protestant attitude toward sex, those changes did not extend to homosexuality. To the contrary, Protestant reformers reaffirmed in no uncertain terms the traditional condemnation of homosexuality as a detestable and abominable sin. In the American colonies, for example, the Puritans declared that sodomy must be punished with death without mercy. By the time of the American Revolution, the colonies, under the influence of the Enlightenment, had stopped using the criminal law to prosecute most forms of consensual sex, except for the crime of sodomy, which remained a capital offense. Indeed, sodomy remained a serious felony in every state in the nation for the next 200 years. Throughout all of this history, until the late 19th century, it was generally assumed that individuals who chose to engage in same-sex sex were no different than other individuals who chose to engage in other types of criminal or sinful behavior. Engaging in homosexual sex, like engaging in murder or robbery, was simply a choice. That assumption began to be questioned for the first time in the late 19th century, as medical authorities became interested in the issue. For the first time, persons drawn to same-sex sex began to be seen as individuals possessed of a distinctive psychological identity. It was in this era that the concept of the homosexual first came into being. Leading studies of homosexuality in the late 19th century posited that homosexuality was a pathology, that persons afflicted with this pathology were strange freaks of nature. Among the questions debated at the time were whether the inclination to engage in homosexual conduct was congenital or acquired, whether it was curable or incurable, and whether it should be accepted as an unavoidable condition or actively resisted and suppressed. Physicians in this era proposed a broad range of remedies for homosexuality, including hypnosis, psychoanalysis, sex with prostitutes, intense bicycle riding, rectal massage, burning the neck and lower back with hot irons, electric stimulation, castration, and clitorectomy. Many doctors recommended the sterilization of homosexuals in order to prevent this condition from being passed on from one generation to the next. And by 1938, 32 states had enacted compulsory sterilization laws aimed at homosexuals. Also in the 1930s, the image of the homosexual took on an increasingly sinister cast. A growing public anxiety over sex crimes recast the dominant image of homosexuals as suddenly dangerous psychopaths who were naturally inclined to commit the most unspeakable crimes against others. Demonized not only as perverts, but now as child molesters as well, homosexuals became the new enemy of the people, and arrests for sodomy increased dramatically in the 1930s. During World War II, the United States, for the first time, attempted to prevent homosexual men and women from entering the military. And those who were discovered in the military were discharged in proceedings that often left them branded for life. With the advent of the Cold War, things got even worse. Fearful of domestic subversion, Americans turned with a vengeance against homosexuals. The conflation of communists and queers seemed only logical, for Americans viewed communism as atheistic, unchristian, immoral, and degenerate. As one congressman asserted in 1950, the Russians are strong believers in homosexuality. And red-baiting journalists warned that communists are now converting American youth to homosexuality in order to defeat us from within. By 1950, the Lavender Scare, as it came to be called, was well underway. Government agencies began using lie detectors to determine whether their employees were homosexuals. The FBI compiled lists of suspected homosexuals from local vice squads, and President Eisenhower issued an executive order declaring sexual perversion, by which he meant homosexuality, a serious security risk. In light of the intensity of the anti-homosexual fever that gripped the nation during the Lavender Scare, gays and lesbians found themselves increasingly isolated. In a society in which the dominant religion excoriated homosexuality as a heinous sin, the law branded it as a vicious crime, and the medical profession diagnosed homosexuals as diseased, the vast majority of individuals who harbored homosexual impulses did their best to hide their secret shame from family, friends, neighbors, employers, and associates. The terrible fear of discovery kept the secret lives of most homosexuals invisible, even to one another. Indeed, even civil rights groups turned their backs on gays and lesbians in this era. In 1957, for example, the National Board of the American Civil Liberties Union declared, quote, "It is not within the province of the ACLU to question the validity of laws aimed at the suppression or elimination of homosexuals." By the late 1960s, though, inspired by the civil rights and the women's rights movements, a handful of courageous gay men and lesbians began calling openly for the acceptance of homosexuals as equals in society. In 1969, for example, Carl Whitman, a gay SDS leader, penned what he termed the Gay Manifesto, in which he declared, quote, "Our first job is to clear our own heads of the garbage that's been poured into them. Liberation for gay people is defining for ourselves who we are. It is time for us to come out." This was the first time that anyone had used the term "come out" in this manner. For those who sought equal rights for gays and lesbians, coming out was a radical and daring act that would affect every aspect of their lives. Indeed, as late as 1969, only a few hundred members of the growing gay rights organizations in the United States had publicly identified themselves as homosexuals. The next decade saw gradual but halting progress in the cause for gay rights. In 1972, a lesbian was allowed to retain custody of her children in a contested divorce for the first time in American history. In 1973, the American Psychiatric Association declared for the first time that homosexuality was not a mental illness. And by the end of the decade, 22 states adopting the recommendation of the American Law Institute had repealed their laws making consensual sodomy a crime. Illinois, by the way, was the first state in the nation to do this. These developments sparked a sharp backlash, however. The most explosive response arose out of a proposed gay rights ordinance in Dade County, Florida. In 1977, the county commission passed an ordinance prohibiting employment discrimination on the basis of sexual orientation. Local religious groups were outraged and demanded an immediate repeal of the ordinance. Local Baptists charged that the law violated God's biblical commandments, and the National Association of Evangelicals soon entered the fray. Leaders of the Christian right, including Jerry Falwell, Pat Robertson, and Jim and Tammy Baker, came to Miami to campaign in favor of repeal. And in the special referendum, Dade County's voters repealed the ordinance by an overwhelming margin. This victory generated momentum for a new religion-based anti-gay movement. The campaign took on an ugly tone as bumper stickers appeared across the nation with such messages as "Kill a queer for Christ." Within 2 years, many of the laws that had been enacted in other cities to protect gays and lesbians from discrimination were also repealed. The Christian right charged during this campaign that such laws promoted child molesting and gay recruiting. And the Reverend Jerry Falwell raged that homosexuals do not reproduce, they recruit, and many of them are after your children. The anti-gay rights campaign saw this fight as a religious battle for the Christian soul of America. Soon thereafter, AIDS struck the gay community with a vengeance. As the disease became associated in the public mind with homosexuality, the Christian right deemed AIDS God's punishment for homosexual sodomy. The Reagan administration, which had actively courted the Christian right, had no interest in devoting government time or money to an illness that was thought to threaten only gay men. Rather than invest federal funds in medical research, the White House instructed the Center for Disease Control, quote, to look pretty and do as little as you can. Over the course of the next decade, AIDS ravaged the homosexual community, killing more than 250,000 gay men and leaving hundreds of thousands more to wonder if they might be next. Ironically, though, the horror of AIDS brought homosexuality into the light. As thousands of gay men died horrible deaths, people had to take notice, often, though not always, with sympathy and concern. Gradually, one person at a time, in often awkward and sometimes excruciatingly painful conversations with family, friends, and acquaintances, the previously closeted lives of homosexuals became visible, first out of necessity and desperation, and then later out of candor and self-respect. Gay invisibility was suddenly melting away. At the Gay and Lesbian March on Washington in 1993, hundreds of thousands of individuals wearing pink triangles marched proudly past the White House. I know because I was there. There's the pin that I wore that day. Now, I have to confess that I wasn't in Washington in order to participate in the march. Rather, I was there for a reunion of Justice William Brennan's law clerks, one of whom I was, at the Supreme Court that happened to be on the same day as the march. But once there, I did participate in the march. But now I want to tell you something that I've only once publicly revealed before. After I got to the Supreme Court for the reunion, the Brennan clerks all gathered in the Supreme Court chamber, and I had a couple of these pink triangle buttons in my pocket. My former wife, Nancy, and I decided that we had to do something in the spirit of the day. And so while I kept guard, she discreetly pinned a pink triangle button on one of the red stripes on the large American flag that hangs next to the bench behind which the justices sit when they are hearing cases. And the last time I checked, it was still there. But don't tell anyone. In any event, to return to my theme, 4 years after the 1993 march, Ellen Degeneres, star of the popular ABC television show Ellen, came out as a lesbian. Shortly thereafter, some 42 million viewers tuned in to watch Degeneres' character, Ellen Morgan, reveal that she too was a lesbian. But not everyone cheered. The response of the Christian right was fierce. The Reverend Jerry Falwell called Ellen Degeneres Ellen Degenerate. And Donald Wildman, the president of the American Family Association, railed that homosexuality was a sin grievous to God and repulsive to Christians. This struggle, he declared, was a matter of life and death, because if we fail, we fear the judgment of God on our nation. The battle lines had been clearly drawn. And that brings me back to the Supreme Court. So as we saw earlier, in its first encounter with homosexuality, the Supreme Court held in Bowers versus Hardwick that a state could constitutionally make homosexual conduct a criminal offense. And the court explained that given the history of religious and moral condemnation of homosexuality, any suggestion that the Constitution could be interpreted as protecting such behavior was, at best, facetious. The court's second foray into this arena was Romer versus Evans, which was decided in 1996, exactly a decade after Bowers. As I noted earlier, beginning in the late 1970s, several cities, like Dade County, had enacted ordinances prohibiting discrimination on the basis of sexual orientation. As in Dade County, however, this generated a sharp response from the Christian right, which usually succeeded in getting the laws repealed. In Colorado, after Denver enacted an anti-discrimination ordinance in 1991, a coalition of Christian right organizations launched an aggressive campaign to amend the Colorado Constitution to override the city's ordinance. Amendment 2, which was adopted in a statewide referendum, provided that neither the state of Colorado nor any of its subdivisions could legally enact any law that protected homosexuals against discrimination. 9 days later, lawyers from Lambda Legal and the American Civil Liberties Union, which had changed its mind by this point, filed suit, claiming that Amendment 2 violated the United States Constitution. In light of Bowers, it seemed clear that the Supreme Court would reject the challenge and uphold Amendment 2. But in a stunning 6-3 decision, the court held Amendment 2 unconstitutional. Justice Anthony Kennedy, who had been appointed to the court by President Ronald Reagan, surprisingly authored the court's opinion. In Kennedy's view, the problem with Amendment 2 was that it imposed a special disability only upon homosexuals. This was so because under Amendment 2, every group in Colorado was free to try to persuade a city council, a state university, or the state legislature to enact laws protecting them against discrimination, except homosexuals. Because of Amendment 2, only homosexuals would have to amend the state constitution before they could obtain any protection against discrimination. And with that fact in mind, Justice Kennedy turned to the Equal Protection Clause of the 14th Amendment, which provides that no state shall deny to any person the equal protection of the laws. Under that guarantee, if a law treats some people differently from others, it ordinarily will satisfy the Equal Protection Clause as long as it bears a rational relationship to some legitimate purpose. And although almost every law passes that highly deferential standard of review, Justice Kennedy concluded that Amendment 2 did not. This was so, Kennedy reasoned, because a law declaring that it shall be more difficult for one group of citizens than for all others to seek aid from the government was virtually unprecedented in American history, and it was therefore impossible to escape the inference, he said, that the disadvantage being imposed on homosexuals by this constitutional amendment was the result not of any rational effort to further a legitimate state interest, but of animosity and antagonism toward the class of persons who were disadvantaged. And because a bare desire to harm a politically unpopular group cannot itself constitute a legitimate government interest, Kennedy concluded that Amendment 2 violated the Constitution. Justice Antonin Scalia, joined by Chief Justice Rehnquist and Justice Clarence Thomas, was of a rather different view. Scalia maintained that Amendment 2 is not the manifestation of a, quote, bare desire to harm homosexuals, but is rather a rational and perfectly legitimate attempt by Coloradans to preserve traditional sexual mores. He castigated Justice Kennedy's reasoning as utterly disingenuous and clearly inconsistent with the court's precedent in Bowers versus Hardwick. The Supreme Court's third decision involving the rights of homosexuals, Lawrence v. Texas, was pretty much a rerun of Bowers. Police officers in Houston were dispatched to a private residence in response to a reported disturbance. After they entered the residence, they saw two men engaging in anal sex. The men were arrested, charged, and convicted of violating a Texas statute, making it a crime for any person to engage in deviant sexual intercourse with another person of the same sex. Since 1982, Bowers v. Hardwick had been used by politicians, legislators, and judges to justify discrimination against gays and lesbians in deportation proceedings, adoption proceedings, military discharges, employment discrimination, and a host of other contexts. After all, if homosexual conduct is criminal, then a homosexual is no different than a rapist, a robber, or a thief. But much had changed in the 17 years between Bowers and Lawrence. Not only had AIDS devastated the gay community and changed the public's perception of homosexuality, but 60% of Americans now thought that homosexual sex should no longer be deemed a criminal offense. And in a 6-3 decision, the Supreme Court overruled Bowers v. Hardwick and held the Texas statute unconstitutional. Justice Kennedy again delivered the opinion of the court. Kennedy maintained that the court's reasoning in Bowers v. Hardwick had been distorted by the court's failure to appreciate the extent of the liberty at stake in such deeply personal relationships. Although conceding that the framers of the Constitution had not expressly guaranteed the right to engage in homosexual sex, Kennedy explained that the framers had intentionally left some constitutional guarantees open-ended because they knew that later generations concede that laws one thought proper, in fact, serve only to oppress and to be unfair. That, Kennedy maintained, was the situation in Lawrence. There was, he concluded, no constitutionally legitimate justification for making same-sex sex a crime. Justice Scalia, joined once again by Rehnquist and Thomas, dissented. Scalia accused the court of signing on to what he termed the homosexual agenda, and he fumed that the court had no business invalidating legislation that had been legitimately enacted by the citizens of Texas. Echoing Justice Scalia's outrage, religious conservatives throughout the nation were livid. Pat Robertson denounced the court for rending the moral fabric of the nation. Jerry Falwell warned that Lawrence v. Texas would lead to bestiality, and a pastor in Kansas fumed that it marked the death knell of American civilization. When it came time for Justice Kennedy to announce the judgment of the court in Lawrence, sitting not far from my pin, he read a brief statement explaining the result from the bench. The Supreme Court chamber was, of course, packed. At the end, he declared, quote, "Bowers v. Hardwick was not correct when it was decided, and it is not correct today. It ought not to remain binding precedent. Bowers v. Hardwick should be and now is overruled." It was a remarkable moment. Overwhelmed by what was happening, many of the gay and lesbian advocates sitting in the gallery openly sobbed. For the gay and lesbian community, it was an occasion for dancing in the streets. Joyous demonstrations erupted in cities across the nation. For gays in America, Lawrence meant much more than that rarely enforced anti-sodomy laws could no longer be enforced. Rather, Lawrence meant that never again would their rights be dismissed to the highest tribunal in the land as, at best, facetious. Never again would they wonder whether the words engraved on the pediment of the Supreme Court building, "equal justice under law," included them. The Constitution was now their Constitution, too. In San Francisco, a group of veterans who had been expelled from military service during World War II because of their sexual orientation proudly saluted as the rainbow flag, which had flown atop an 80-foot pole for more than 5 years, was lowered, and an American flag, for the first time, was raised in its place. For most of American history, the notion that a man could marry a man or a woman could marry a woman seemed utterly absurd. In 1990, however, only 4 years after Bowers v. Hardwick, 3 gay couples in Hawaii applied for marriage licenses, which were, of course, denied. Audaciously, they then filed suit in state court, claiming that the state's refusal to allow same-sex marriage violated the Hawaii Constitution. To pretty much everyone's surprise, the Hawaii Supreme Court ruled in 1993 that the state's law restricting marriage to a man and a woman might indeed violate the Hawaii Constitution. This decision provoked a furious response from the Christian right, and almost immediately states across the nation rushed to amend their state constitutions explicitly to define marriage as involving only one man and one woman. The goal of these amendments was both to prevent their own state courts from following the Hawaii Supreme Court suggestion and to make it impossible for future majorities in the state, should they ever emerge, to legalize same-sex marriage by enacting legislation to that effect. These issues played out at the national level as well. As the 1996 election approached, the anti-gay rhetoric was virulent. Dick Armey, the Republican whip in the House, publicly referred to Congressman Barney Frank as Barney Fag. And Republican Speaker of the House Newt Gingrich proposed the Defense of Marriage Act, or DOMA, which provided, among other things, that if any state were to recognize marriages between persons of the same sex, persons entering into such marriages would be ineligible for any of the multitude of federal benefits that were otherwise available to married couples. The hearings on DOMA were openly homophobic. Members of Congress described gays and lesbians as, quote, sick, perverted, and dangerous, charged that the nation was facing a dangerous attack upon God's principles, and warned, quote, that the flames of hedonism are licking at the foundations of our society. Congress quickly enacted the legislation, and with the presidential election just around the corner, and with the American people opposed to same-sex marriage by a margin of 68 to 23%, President Bill Clinton signed DOMA into law. Of course, none of this really mattered at the time because same-sex marriage was not legal in any state in the nation. 7 years later, though, in 2003, the Massachusetts Supreme Court held that laws denying same-sex couples the freedom to marry violated the Massachusetts Constitution. Massachusetts thus became the first state in the nation to legalize same-sex marriage. In response, 13 additional states promptly amended their state constitutions to make clear that they prohibited same-sex marriage. Several years later, though, the Supreme Courts of Connecticut, California, and Iowa followed Massachusetts' lead and held that their state constitutions also guaranteed same-sex couples the right to marry. But the pushback, again, was furious. In California, for example, the Christian right launched a vigorous and successful campaign to amend the state constitution to outlaw same-sex marriage and to override the Supreme Court's opinion. And voters in Iowa, spurred on by the moral majority, voted out of office 3 of the state Supreme Court justices who had voted to recognize a state constitutional right to same-sex marriage. As the executive director of the American Family Association warned, if any judge attempts to impose an immoral agenda on us, we are going to take you out. Thus, despite several seemingly landmark victories, the movement for same-sex marriage had stalled. DOMA remained the law nationally. Most efforts to legalize same-sex marriage had been overturned, and by 2013, more than 30 states had enacted state constitutional amendments expressly outlawing same-sex marriage. This brings me to the Supreme Court's 4th decision in our story, Windsor versus the United States. In a bitterly divided 5-4 decision, the Supreme Court invalidated DOMA on June 26, 2013, 10 years to the day after its decision in Lawrence. As in Romer and Lawrence, Justice Anthony Kennedy again authored the opinion of the court. He was joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. Chief Justice Roberts and Justices Scalia, Thomas, and Alito dissented. In his opinion for the court, Justice Kennedy explained that the issue presented was not whether the states were constitutionally obligated to recognize same-sex marriage. Rather, the issue was whether the federal government could constitutionally discriminate against couples who had been legally married in a state because those individuals happened to be of the same sex. In approaching that question, Justice Kennedy emphasized that a state's decision to give same-sex couples the right to marry conferred upon them a dignity and a status of immense importance. DOMA's principal effect, Kennedy maintained, was to identify a subset of state-sanctioned marriages and to make them unequal. Kennedy argued that by placing legally married same-sex couples in the position of being second-tier marriages, DOMA demeaned the couple and humiliated tens of thousands of children who were then being raised by same-sex couples. Because no legitimate federal interest justified a law disparaging those whom the state had sought to protect, Kennedy concluded that DOMA violated the Constitution. In a furious dissenting opinion, Justice Scalia characterized the court's reasoning as nothing short of remarkable. At various points, Scalia dismissed Kennedy's analysis as, quote, perplexing, confusing, absurd, overcooked, and legalistic argle-bargle. Scalia reiterated what he had insisted upon in Lawrence. The Constitution does not forbid the government to enforce traditional moral and sexual norms. And Scalia angrily predicted that Windsor would lead to recognition of a constitutional right to same-sex marriage. As far as this court is concerned, he fumed, quote, no one should be fooled. It is just a matter of waiting for the other shoe. Now, it's striking how far the court had moved in the 27 years from Bowers to Windsor. This was due to several factors, one of which was not an overall move of the court in a more liberal direction. To the contrary, on a broad range of issues, including affirmative action, campaign finance, gun control, and voting rights, to name just a few, the Supreme Court, with the additions of Justices Scalia, Kennedy, Thomas, Roberts, and Alito, had moved, if anything, notably more conservative than the court had been at the time of Bowers. What had changed in those years was the public awareness of gays and lesbians in society and the public and legal understanding of both the morality and wisdom of laws discriminating on the basis of sexual orientation. Indeed, public opinion on those issues had shifted dramatically between Bowers and Windsor. In 1986, no one had even bothered to poll on the question of same-sex marriage. The idea seemed ludicrous. It wasn't until 1996 that Gallup finally thought to ask people about same-sex marriage, and at that time, only 22% of Americans thought that same-sex marriage should be legal. By 2013, however, 54% of Americans shared that view. This shift was due to many factors, but most important was the profound change in the visibility of gays and lesbians in American society. This transformation affected not only everyday citizens, but also, of course, legislators, mayors, governors, president, and judges. And with these changes, the traditional judicial understandings of such fundamental legal concepts as liberty, equality, and due process, as applied to homosexuals, were suddenly called into question, and rightly so. But it's important to note that those changes in public attitudes and understandings did not in themselves dictate any particular change in constitutional doctrine. Bowers and Windsor were both 5-4 decisions. Only one vote had changed over the course of those 27 years. Had Robert Bork been confirmed to the Supreme Court, and Anthony Kennedy therefore never been appointed to the court, the outcome of Windsor almost surely would have been 5-4 the other way. So my point is that the divergent outcomes in these cases were shaped by at least two critical factors: the general public understanding of homosexuality at the time of the decisions, and the particular interpretive approaches and values of the individual justices who happened to be on the Supreme Court at the specific moment when the issues arose. In the years after Windsor, there was a virtual avalanche of lower court decisions invalidating state laws denying same-sex couples the freedom to marry. The other shoe, as Scalia predicted, was indeed about to fall. In Obergefell versus Hodges, decided on June 26th of this year, 2 years to the day after Windsor, the Supreme Court, in another bitterly divided 5-4 decision, held that states cannot constitutionally deny two persons of the same sex the freedom to marry. The opinion, written once again by Justice Anthony Kennedy, was premised on what Justice Kennedy described as the transcendent importance of the right to marry. Marriage, Kennedy proclaimed, allows two people to find a life that cannot be found alone, for it rises from the most basic human needs and is essential to our most profound hopes and aspirations. Although conceding that marriage had traditionally been understood as between a man and a woman, Kennedy declared that it is both appropriate and inevitable in a free society that new dimensions of freedom become apparent to new generations of Americans over time. Noting that the court had long held that fundamental personal choices central to individual dignity and autonomy can be protected by the Constitution, even if they are not explicitly listed in the Constitution, and that the court had long recognized marriage as one of those implied fundamental rights, Kennedy concluded that although the limitation of marriage to opposite-sex couples may have long seemed natural and just, its inconsistency with the central meaning of the fundamental right to marry is now manifest. Predictably, Chief Justice Roberts and Justices Scalia, Thomas, and Alito were vigorous in their dissents. Roberts accused the justices in the majority of rampant and reckless judicial activism. The majority's decision, he declared, quote, is an act of will, not legal judgment. The right it announces has no basis in the Constitution. Justice Scalia, Thomas, and Alito authored similarly scathing dissenting opinions. Justice Scalia, for example, charged that the majority's opinion lacks even a thin veneer of law, and that it is, quote, a naked judicial claim to super legislative power fundamentally at odds with our traditions and our system of government. Justice Thomas added that the majority's decision threatens the religious liberty that our nation has long sought to protect, and Justice Alito railed that the decision evidenced, quote, a deep corruption of constitutional interpretation. So who is right? The mere fact that 5 is more than 4 does not necessarily make the 5 correct, even though it makes the law. So who was right? Let me offer a few observations. First, the fury expressed by the dissenters in their condemnation of the majority's opinion in Obergefell is completely unwarranted. Although there are reasonable grounds to disagree with the court's decision, and I'll get to them in a moment, there is nothing about the decision itself that merits the screeching charges of judicial usurpation of the democratic process hurled by the 4 dissenters. Indeed, those very same justices have embraced highly controversial and activist interpretations of the Constitution in awarding, for example, the 2000 presidential election to George W. Bush, in holding affirmative action programs unconstitutional, in holding gun control regulations unconstitutional, in holding laws regulating campaign expenditures and contributions unconstitutional, and in holding the Voting Rights Act of 1965 unconstitutional, to cite just a few examples. For them to purport to stand tall on the pedestal of judicial restraint is nothing short of hypocrisy. Second, there are, in fact, reasonable grounds on which to disagree with the court's analysis. In invalidating laws prohibiting same-sex marriage, Justice Kennedy relied specifically on the argument that marriage is a fundamental right and that government therefore cannot constitutionally limit the right to marry, even to same-sex couples, without a compelling justification. But the very notion that the Constitution protects unenumerated rights that are not mentioned in the Constitution has always been a highly controversial concept. Though the Constitution expressly protects the freedom of speech, the freedom of religion, the freedom from unreasonable searches and seizures, and other expressly delineated rights, a central puzzle in constitutional interpretation has always been whether the Constitution implicitly also protects other rights that have not been expressly spelled out in the text. Now, historically, the court has recognized that such rights exist, including, for example, the right not to be sterilized, the right to use contraception, the right to privacy, the right to vote, the right to decide for oneself whether to bear or beget a child, the right to raise one's own children, the right to travel, the right to vote, and so on. But the recognition of such unenumerated rights is always a tricky business, because it gives the justices potentially enormous authority to override the democratic process by imposing their own particular value judgments about what they happen to think to be fundamental rights. So as the dissenters in Obergefell argued, one constraint that has sometimes been suggested by the justices is that the court should recognize an implied fundamental right only if the claimed right is one that has been deeply rooted in our nation's history and tradition. Marriage, of course, is such a right. But as the dissenters argued, how we think about that in the context of same-sex marriage is complicated. What is deeply rooted in our nation's history and tradition, they argue, is marriage between two persons of the opposite sex, not marriage between two persons of the same sex. Thus, in their view, the court in Obergefell was not protecting a right that was deeply rooted in our nation's history and tradition, but instead creating an entirely new right out of whole cloth, a position, they insist, that is beyond the legitimate authority of the Supreme Court. Now, although this is a reasonable argument, it is not compelled by the actual practice of the court, which over time has not limited itself to defining constitutional fundamental rights in this manner. But the point is certainly an arguable one, and the dissenters' objection on this score is far from crazy or irresponsible. Third point I want to make is that my own view is that the court in Obergefell made the wrong argument, that it should have decided the case not on the ground that marriage is a fundamental right, but on the ground that discrimination against gays and lesbians violates the Equal Protection Clause. And I say this for two reasons. The first of which is obvious, is that I think it is a stronger argument legally and less open to the kind of challenge that I stated a moment ago. I'll come to my other reason later. So the Supreme Court generally holds that laws are consistent with the Equal Protection Clause as long as they rationally further a legitimate state interest, a highly deferential standard. But the court has also held that laws that discriminate against individuals on the basis of so-called suspect criteria are especially problematic under the Equal Protection Clause, and that they are unconstitutional unless they can survive a highly demanding standard of justification. Now, because laws discriminating against African Americans are the paradigm violation of the Equal Protection Clause, the court generally considers several factors in deciding whether discrimination against any particular group should be deemed similarly suspect. First, whether the group has experienced a long history of invidious discrimination. Second, whether the defining characteristic of the group is essentially immutable or unchangeable. And third, whether the group can effectively protect itself against discrimination through the political process. Now, those who challenge the constitutionality of laws that discriminate against gays and lesbians maintain that such discrimination satisfies these criteria, and that such laws should therefore be understood as presumptively unconstitutional for equal protection reasons. In response, those who defend the constitutionality of laws discriminating against gays and lesbians maintain that homosexuality is a choice, that what homosexualities call a history of discrimination is therefore no different than a history of discrimination against arsonists, robbers, and murderers, and that gays and lesbians in any event have ample political power. In their view, then, laws that discriminate against homosexuals are completely different constitutionally from laws that discriminate against African Americans or women or Hispanics or Japanese Americans, all of which the court have held are constitutionally suspect. In my view, this rationale, this equal protection argument, would have been a much better basis for the court's decision than its reliance on marriage as a fundamental right, not only because I think it's a stronger argument, but also because it would resolve all discrimination against gays and lesbians, not only the issue of marriage. Why do I think this is a strong argument? Well, gays and lesbians have clearly been subjected to a long history of invidious discrimination. Sexual orientation is not a matter of choice, and gays and lesbians have consistently had their interests dismissed and overridden in the political process. Put simply, and especially in light of that history and the history I described earlier, laws that discriminate against gays and lesbians, whether in marriage, in child custody disputes, in employment, in housing, or in any other context, should properly be deemed constitutionally suspect in the sense they are highly likely to be tainted by considerations of animus, hostility, ignorance, and prejudice. This, to me, is the deepest and truest reason for invalidating all laws that discriminate against gays and lesbians. I'd like to close with one final observation. For most of American history, a particular understanding of religion dictated the laws on issues like sexual expression, obscenity, contraception, abortion, and homosexuality. In the last half-century, due largely, though not entirely, to the Supreme Court of the United States, those religious values have been pushed aside, and individuals have increasingly been freed to act on their own personal and religious beliefs, rather than to be dictated to by the religious beliefs of others. This is, in my view, a great achievement in a society dedicated to the separation of church and state. But it now does leave us with an interesting challenge. For a constitution also guarantees the freedom to practice one's religion. And with the demise in these respects of the religious state, those who hold to traditional Christian values now find themselves on the defensive. No longer able to dictate that others must act in accord with their religious beliefs, they now demand that they at least be permitted to act in accord with their own religious beliefs. Hobby Lobby demands the right not to provide certain contraceptives to its women employees. Kim Davis demands the right not to sanction same-sex marriages. Catholic priests demand the right not to marry same-sex couples. And florists, bakers, hotel owners, and restaurant owners demand the right not to have to participate in same-sex weddings. These are not easy questions for one who values both the separation of church and state and the freedom of religion, as do I. And those are issues that the court and society will continue to have to wrestle with as we go forward. But perhaps the most astonishing thing about the Supreme Court's decision in Obergefell is that the backlash, which was so anticipated, has in fact been so tepid. Now that may change over time, but I think not. This is not abortion. Those who oppose abortion sincerely believe that it is the murder of children. And if one believes that abortion is the murder of children, it is easy to understand why you do not give up the fight. On homosexuality, the reality is that for most people, they can live with it. They didn't think they could, they never imagined they could, but they can. So thus far, the response, with a few odd exceptions like Kim Davis, has been almost non-existent, even in the states one would have most expected a vociferous response. And we can and should bask in the glory that our nation has taken another important step in our protection of human dignity and citizenship and equality. We have many steps left to take, but this is one that we can genuinely celebrate together. But to gain similar celebrations in the future, we constantly have to challenge the accepted wisdom. No one in this room would have imagined 25 years ago that the Supreme Court of the United States would have held that gays and lesbians have a constitutional right to marry. That was virtually unthinkable. And we must always remember that we, like those who went before us, hold beliefs that our children and our children's children will rightly come to regard as naive, foolish, and bigoted, even though we don't understand that at the moment. And as we strive to fulfill the obligations of citizenship in a free society, we have to have the courage, the open-mindedness, and the integrity to question the conventional wisdom and always to challenge the nature of things. Thank you.